Welcome. My name is Nadia Zaim, and I am the chair of the Pretrial Procedures Subcommittee, and this is a brief overview of our recommended positions. We initially intended to study both pretrial and trial procedures, so every aspect of a criminal case from arrest to conviction. It soon became clear to us that the vast majority of cases, however, never go to trial. In fact, in Ohio, over 97% of cases are pled out. We therefore focused our research on pretrial procedures, those that have the most effect on the criminal justice system, including funding, grand juries, bail and pretrial detention, indigent defense, plea bargaining, and specialized dockets. I will now briefly go over our proposed principles and positions, as well as the basis for those positions. But if you want more information on our process, our research, and these positions, you can review our full position paper on the member corner of the LWVO website. Our first position has to do with funding. In Ohio, there is not only inadequate funding for certain areas of pretrial procedure, but that funding is often inconsistent throughout the state. Funding of pretrial procedures is often at the local or county level, rather than the statewide level. Adequate annual funding by the General Assembly is necessary for the efficient and equitable administration of justice. We therefore recommend adopting a position that adequate and equitable annual funding by the General Assembly for courts throughout the state of Ohio, including for pretrial services, indigent defense, and specialized dockets, taking into consideration the unique and varied needs of those courts. Prosecutors have significant power throughout the pretrial process. While law enforcement is primarily responsible for investigating crime, it is the prosecutor who decides whether someone is charged with a crime and what crime or crimes that person is charged with. In Ohio, in order to bring felony charges, crimes that could result in imprisonment, prosecutors must present the charges to a grand jury and seek an indictment. Historically, grand juries have served as a check on the government's power. There is growing concern, however, about the independence of grand juries. Ultimately, prosecutors have the power to decide what cases to bring, what charges to pursue, and what evidence to introduce in pursuit of an indictment. Grand juries, when operating independently, play an indispensable role acting as a check on that power. We therefore recommending adopting positions that require adequate training of grand jurors by a neutral party to ensure their independence, giving the defendant a right to get the transcript of grand jury witnesses, especially when that witness is later called to testify at their trial. Ensuring that prosecutors, when they pursue charges, do not overcharge and have a good faith belief in the guilt of the defendant. And maintaining a database that includes data on the number of cases brought before grand juries and the number of those cases which are actually resulting in indictments. Even with some recent changes to Ohio's bail and pretrial detention system, there is still more that can be done to ensure that the system is fair while at the same time protecting the public. Studies have shown that pretrial detention increases not only the likelihood of conviction, but also the likelihood that the person will receive a prison sentence and a longer prison sentence, while decreasing pretrial detention and prioritizing alternatives to detention can also result in significant cost savings to the state and to counties. Ohio recently made some changes to bail and pretrial release, but it is still unclear what effect, if any, those changes will have. Bail and pretrial detention decisions should be made without regard to race, ethnicity, sexual orientation, gender identity, gender expression, age, disability, religion, nationality, or socioeconomic status. All persons should be accorded the presumption of innocence and the privileges consistent with that assumption. We therefore recommend adopting these positions: that there be a presumption of pretrial release and the use of alternatives to detention, that a preliminary determination be made as soon as possible after arrest, ideally within 24 hours, that a defendant have access to counsel at their initial appearance, that the use of risk assessment tools be only where those tools are designed and implemented in ways that avoid bias, that courts use technology such as text and email reminders and remote video conferencing and other low-cost improvements to ensure a defendant's appearance, and maintaining a database, including data on the charges, the demographics of the defendant, and the determination as to bail, pretrial release, or detention. The funding and administration of indigent defense is fundamental to our criminal justice system. The form of indigent defense varies from county to county in Ohio. While some counties have only public defenders and some counties only have appointed counsel, other counties have a hybrid of both public defenders and appointed counsel. There is a disparity, however, between the resources that are available to public defenders and appointed counsel. Public defenders not only have access to things like in-house investigators, experts, and social services, they are also paid at a rate near or at parity with prosecutors. While appointed counsel can request reimbursement for expenses like investigators and experts, they are not reimbursed at the same rate of the actual cost, and they are generally paid at an hourly rate significantly lower than the rate of other private attorneys. The constitutional right to indigent defense is fundamental. Unstable, inadequate, and inequitable or unreliable funding of indigent defense jeopardizes the right of indigent criminal defendants to competent, effective counsel. We therefore recommend adopting these positions. The supplementary and coordinated use of assigned counsel with public defenders, with a standardized set of rules and fees to ensure the adequate supply of counsel, a system that has sufficient funding to meet the needs of each community and the need for adequate salaries, investigators, staff, and other administration. Maintaining a database, including data on the number of cases in which a public defender or an appointed counsel has been appointed. Plea bargaining is a useful tool in the judicial process, one that should be controlled and formalized. It allows the overwhelming percentage of criminal cases to be disposed of quickly. There is also the potential for abuse, however, with a prosecutor charging higher level offenses in order to get a defendant to plead to a lesser offense. Because so many cases are disposed of through the bargain guilty plea, plea bargaining must be conducted in accordance with a fair, standardized, and transparent process. We therefore recommend the following positions: increasing transparency of the process, including requiring that any plea bargain discussions with the judge be on the record and entered into and maintained in a database, including data on the original charge, the plea, and the resulting sentence. Ensuring prosecutors abide by their duty in maintaining charges to have a good faith belief in the guilt of the defendant beyond a reasonable doubt. A defendant who agrees to a plea bargain should have a reasonable expectation of the sentence that will be imposed prior to them pleading guilty. Specialized dockets, sometimes also called specialty courts, are separate dockets in Ohio that focus on specific needs of defendants and allow for the treatment of the circumstances that may have contributed to the offense, including mental health, substance abuse, PTSD, and post-release needs. The use of these courts and other treatment programs varies from county to county because some counties lack the funding and the resources to provide these services to defendants in their courts. Although some funding is available from the state, courts generally have to rely on funding from local or county level. This limits the number of individuals who can participate in these programs and may only allow courts to help those with the most severe circumstances. It should be recognized that mental health conditions and substance abuse addictions are public health issues and not crimes. And community-based treatment programs are necessary to address these issues. We therefore recommend adopting the following positions: implementing and expanding community-based treatment programs for all nonviolent offenders and appropriate science-based mental health addiction evaluation and treatment of offenders. Allocating adequate funds to all courts in Ohio to ensure that these programs can be implemented. Providing all stakeholders with regular training on issues of mental health and addiction. And maintaining a database, including data on the number of defendants participating in these programs and the outcome of that defendant's case. So what can you do? First, you can read our full report on the member corner of the LWVO website. Second, you can become a delegate to the LWVO convention and vote yes to concur with the board's recommendation to adopt these positions. Three, you can monitor what's happening at the state house and in your local community. And finally, you can talk to your state and local representatives to advocate on behalf of these principles and positions. On behalf of our subcommittee, I would like to thank you for taking the time to watch this video. I encourage you to watch the videos of the other 4 subcommittees. And if you have any questions about our recommended positions, or you would like to help us adopt these policies and positions, please contact me at the email address on your screen. Thank you.